Good morning. Thank you for joining us today. It's nice to see some familiar faces. Today we are going to talk about the Illinois Community Reinvestment Act and provide you with an update. Just as a reminder, this webinar is being recorded. At the top, I will share this disclaimer. The information and views shared by me in this presentation does not represent the views or thoughts of the Illinois Department of Financial and Professional Regulation or that of the governor. This information should not be construed as legal advice or as formal interpretation of the Illinois Community Reinvestment Act rules. The agenda, today we will cover an overview of the Illinois CRA, the scope, differences from the Federal CRA, alternative and very small bank examination procedures, data collection, reporting and disclosure, content and availability of public information, public notice, public comment process, publication of planned examination schedule, examination frequency and coordination, exam fees, effect of Illinois CRA performance on applications, performance evaluation format, an update of our regulatory staff and other initiatives, and we will close it off with a Q&A. So, in the overview, the Illinois CRA covers other financial institutions other than banks, and that includes credit unions and mortgage lenders, non-depository mortgage lenders. And the definition of bank also includes FDIC-insured banking office of a foreign banking corporation. Of course, the rules went into effect on May 1st, 2024. And this was after about a year and a half of discussions, public hearings, and formal comments by industry and the public. And the implementation period for banks started on February 1st, 2025 for banks with total assets of $391 million or greater. For all banks with total assets under $391 million, this will not take effect until August 1st, 2025. The asset size is based on your year-end call report. The scope of requirements for banks is structured largely around federal rules, but also includes fair lending review, which I'll discuss in more detail later in this presentation. Submission of data, unless directed otherwise, please continue to submit data to the bank's primary federal financial supervisory agency, whether that's FDIC or the Federal Reserve Bank of Chicago or St. Louis. And note that we are evaluating how to submit HMDLR. Next, except where required, the rules are to be construed and interpreted consistently with the appropriate federal financial supervisory agencies' construction and interpretation of the Federal CRA rules. The department's intent is to refer to the pre-April 1st, 2024 Federal CRA rules. The Illinois CRA will not apply to special purpose banks that do not perform commercial or retail banking services by granting credit to the public in the ordinary course of business other than as incident to their specialized operations. So let's get into what are the differences compared to the Federal CRA. We will start off with the definitions, and generally the definitions track the Federal CRA with some additional definitions such as special credit program used in Section 220, unbanked person, and underbanked person. However, the definition of community development was expanded to include climate-related activities targeted to directly and tangibly increase climate resilience in low-income to moderate-income neighborhoods or mitigate environmental harm in low to moderate-income neighborhoods. Note here is a small bank may elect to be evaluated under the General Lending, Investment, and Service Test, but only if it collects and reports the data required for other banks under Section 345.410. Another key difference is in the assessment factors. The Federal CRA rules do not explicitly define assessment factors that the federal banking agencies will take into account in determining whether a bank is meeting its obligations under the Federal CRA. Under the Illinois rules, there are 9 factors that IDFPR is required to consider in assessing a covered financial institution's compliance with the Illinois CRA. These 9 factors are outlined in the PowerPoint, number 1, activities to ascertain the financial services needs of the community, including communication with community members regarding the financial services provided. Number 2, extent of marketing to make members of the community aware of the financial services offered. 3, origination of mortgage loans, including but not limited to home improvement and rehabilitation loans and other efforts to assist with existing low-income and moderate-income residents to be able to remain in affordable housing in the neighborhood. 4, origination of small business loans to businesses with gross annual revenues of $1 million or less, particularly those in low-income and moderate-income neighborhoods. 5, participation, including investments in community development and redevelopment programs, small business technical assistance programs, minority-owned depository institutions, community development financial institutions, and mutually owned financial institutions. 6, evidence of discriminatory and prohibited practices. 7, efforts working with delinquent customers to facilitate a resolution of the delinquency. 8, origination of loans that show an under construction and systemic pattern of lending and the loss of affordable housing units. And last, offering retail banking services to unbanked and underbanked persons. Some of these, if not most of them, are included in the Federal CRA Fair Lending exam. We have incorporated this into our assessment areas, or sorry, assessment factors for the Illinois CRA. Ratings. There are no material deviations from the Federal CRA. However, Section C, effective evidence of discriminatory or other illegal credit practices, includes citations to Illinois as well as federal anti-discrimination laws. It also includes, as an example of an EQA or Fair Housing Act violation, relying on or giving force or effect to discriminatory appraisals to deny loan applications where the covered financial institution knew or should have known of the discrimination. This one is new, alternative and very small bank examinations. IDFPR may establish alternative examination procedures for banks rated outstanding as of their most recent Illinois CRA or Federal CRA examination. No such procedures have been established yet, but note the additional year between exams already provided in Section 470. Any bank at the time of examination that satisfies either of the following eligibility standards as shown in its year-end call report and other related documentation may elect to use the very small bank examination procedures. Total assets less than 25 million or total assets less than 100 million that lent or originated less than 50 residential mortgage loans reportable under the Home Mortgage Disclosure Act in the previous calendar year. It's important to note that the 100 million threshold shall be adjusted so that it is equivalent to the corresponding threshold for state chartered credit unions based on amendments made by the National Credit Union Administration from time to time in its definition of small entity for purposes of the Federal Regulatory Flexibility Act. These procedures are not available under limited circumstances. A bank that receives an overall rating of substantial noncompliance on its last examination. In the case of an Illinois CRA, examination pursuant to section 345.470D1. Moving on, a bank has at least 3 months to complete the examination and also has the opportunity to review its proposed response with an examiner before the due date. A bank is required to submit written responses, including description of the bank's efforts to ascertain the financial services needs of the bank's assessment area, description of extent of marketing, if any, to make the bank's assessment area aware of the financial services offered and supporting documentation, description of the bank's efforts and successes, if any, to assist existing low-income and moderate-income residents in the bank's assessment area to be able to remain in affordable housing in their neighborhood. There are other items or factors that IDFPR in its discretion may also require, such as HMDLR quarterly reports along with loan and applicant demographic information, details and supporting documentation of small business loans, bank participation and investments in community development and redevelopment programs, description and supporting documentation of efforts and successes working with delinquent customers in the bank's assessment area to facilitate a resolution of the delinquency, description and supporting documentation of efforts and successes to offer retail banking services to unbanked and underbanked persons in the bank's assessment area. Written response to public comments, if any, received since the bank's last Illinois CRA examination, and any other information the bank believes is relevant to assessing whether the bank is meeting the financial services needs of the bank's assessment area. Data collection, reporting, and disclosure. In general, the Federal CRA rules require a bank to collect, report, and maintain certain loan applications and information. The Illinois CRA rules are substantially similar, and there are no material deviations from the Federal CRA rules. There are specific deadlines that you should know. A bank, except a small bank or a bank that was a small bank during the prior calendar year, shall report annually by March 1st to IDFPR in machine readable form. We have decided Excel is this readable form for the prior calendar year. A bank except a small bank for credit. I did read that. All right, for 2025, since the rules became effective on May 1st, we have received questions on this, so we are answering that with this. Banks that did not have a full year of HMDA and CRA data to provide, the 2024 data is not required to be submitted under the Illinois CRA. For 2026, under the Illinois CRA, submit 2025 HMDA and CRA small business and small farm data in Excel format to the Illinois CRA email address, which is fpr.cra.banks@illinois.gov. Contents and availability of public files. In general, again, the Federal CRA rules require a bank to maintain a public file that includes certain information. The Illinois CRA rules are substantially similar, and there are no material deviations from the Federal CRA rules. I'd like to point out that a bank shall make available to the public for inspection upon request and at no cost the information required. At the main office, and if an interstate bank at one branch office in each state, all information in the public file. And at each branch, a copy of the public section of the bank's most recent Illinois CRA performance evaluation and a list of services provided by the branch. Number 2, within 5 calendar days after the request, all the information in the public file relating to the assessment area in which the branch is located. Public notice by banks. We have also received several questions about this section. We hope that we're able to clarify that now. So public notice is generally consistent with the Federal CRA, which requires public notice to be made available in the public lobby of a bank's main office and each of its branches. Illinois CRA also requires notice on the bank's website. We recommend using the main office version of a bank's website. The website notice does not replace the Illinois CRA's requirement of physical posting. Appendix B, which we have shared with everyone, and we're happy to do that again, supersedes Division of Banking's May 1st, 2021 supervisory statement. If a bank has out-of-state branches, place the branch office version in one branch in each state. And then to reiterate, the Illinois CRA notice is separate and distinct from the Federal CRA form. Both notices are required. Public notice by banks with a holding company. The notice concerning the announcement of Illinois CRA covered applications filed by a bank holding company should be directed to Colette Freed, Assistant Vice President at the Chicago Federal Reserve Bank. The address is provided here, and to the officer in charge of consumer compliance at the Federal Reserve Bank of St. Louis, and the address is also provided here. The public comment process. Under Section 345.420A1, a bank's public file must include written comments and any response by the bank, subject to limited exceptions. Comments received by IDFPR will be kept on file for use by examiners, and IDFPR may also request that a bank respond. Note, this is different from the more specific public comment process for strategic plan development, Section 345.270. The publication of planned exam schedule is posted on our webpage. It is consistent with the Federal CRA. We are publishing the exam schedule 30 days before the beginning of each calendar quarter of the scheduled exams in that upcoming quarter. So as you can see, in the first quarter of 2025, we conducted 2 exams, First Secure Community Bank in Sugar Grove and First Eagle Bank in Chicago. For the second quarter, we conducted the Community Savings Bank exam, and we are about to commence the Citizen State Bank in Lena. The third and fourth quarter, there's a typo there, I will correct that, will be posted on the dates referenced here, June 1st for third quarter and September 1st for the fourth quarter. The frequency and coordination of examination, we in coordination with a bank. We are working in coordination with the primary federal financial supervisory agency, whether it's FDIC or the Federal Reserve Bank of St. Louis or Chicago. We are coordinating with them as much as possible. Information sharing and coordination agreements are in place for the FDIC, and we are in the process of finalizing this for the Federal Reserve Banks of Chicago and St. Louis. The initial examination schedule is based on total asset size. Banks under 10 million in total assets will be conducted within 6 years, commencing on August 1st. And banks from 10 million to under 391 million is also in that same bucket of August 1st. For any bank 391 million and above, these exams commence on February 1st, 2025, and shall be conducted within 4 years and within 3 years, respectively, for 391 to under 1 billion and 1 billion or more. For the initial examination schedule, it's important that I note to all of you that the 2023 call report will be utilized. We understand that there are some questions with regards to this, so it's the 2023 call report for the initial examination, unless the 2024 call report is available. Subsequent examination schedule will be based on asset size and assigned ratings as detailed in this table. If your institution is rated outstanding, it could be scheduled within 5 years or initiated within 3 years, depending on the asset size. For satisfactory, it's 4 and 3. 4 needs to improve, it's 2 years, and substantial noncompliance, it's every year. Examination fees. I'm actually going to go back to the frequency and coordination. I just want to note that other reasons when IDFPR may conduct an Illinois CRA exam is for substantial noncompliance by the primary federal financial supervisory agency, if there's substantial evidence of discriminatory or other illegal credit practices, or if IDFPR otherwise finds sufficient cause. Examinations for outstanding or satisfactory rated banks may be extended by 1 year if IDFPR finds an extension is necessitated in order to examine banks within a needs to improve or substantial noncompliance rating, or showing substantial evidence of illegal credit practices. There may be inconsistencies with FDIC and the Federal Reserve Bank schedules, but our goal is to align as much as possible. All right, examination fees. The Illinois CRA annual fees are based upon a bank's total assets in the consolidated report of condition and income for the quarter ending March 31st. The fees are due on July 31st, 2025 for fiscal year 2026. Our fiscal year begins on July 1st, and for all subsequent years on July 31st. When out-of-state travel occurs in the conduct of any examination, the bank shall make arrangements to reimburse the department all charges for services such as travel expenses, including airfare, hotel, and per diem incurred by the employee. The annual fee schedule is included in this table, and I will show that in the next slide, and it's also available in the CRA rule. If your institution has total assets of less than 10 million, there is no charge, and then it's increasing based on the asset size. as we will require more time and more examiners the larger your institution is. Moving on to the effect of Illinois CRA performance on applications. IDFPR considers all Illinois CRA performance in considering relocation of a bank's main office or branch when express prior approval is required under state law. Merger, consolidation, acquisition of assets, or assumption of liabilities as it's defined in Section A of 345.290. A new financial institution, a de novo bank, must submit a description of how it will meet Illinois CRA objectives. We will take into account views of interested parties, and then a bank's record of performance may be the basis for denying or conditioning approval of an application. Performance evaluation format. For the 4 banks that have already, or 3 banks that have already experienced their exam and the one upcoming, they've seen this information already. But you should know that it's substantially similar to the Illinois CRA, except in that it contains the confidential section. So this is a typo. It's substantially similar to the Federal CRA, except that it contains a confidential section. The confidential section includes assessment factors and a fair lending review. For a small bank, the community development test would not be included. An update on the regulatory staff. Since our last webinar or meetings that we've had with other organizations, we do have an interim CRA supervisor, and we're in the process of trying to hire a full-time CRA supervisor. We do have 5 examiners, actually 4 examiners and 1 trainee for banks. We are in the process of hiring a CRA examiner for the mortgage, on the mortgage side, and then for the Division of Financial Institutions that is responsible for the credit unions, they are in the process of hiring a CRA supervisor and have 1 examiner for credit union exams. Other initiatives, it's important that I talk about the Banking Development District Act. This act, the purpose is to encourage the establishment of banking branches for banking services in geographic locations where there are greatest underbanked and unbanked populations. The rules were approved in 2024. We are in the process of updating our webpage to include information with regards to Banking Development District Act. And we are working with the Treasurer's Office, as this is a joint effort with them. If your bank does proceed with an application and establish a bank using the Banking Development District Act, there is a potential for you to receive credits on CRA for this, as well as other possible opportunities, like depending on the municipality, but public funds as well. And then Appendix C, it provides examples of community development. The CRA rules definition of community development activities has been expanded to include a list of 9 enumerated activities. The final item refers to the Office of the Comptroller of the Currency CRA illustrative list of qualifying activities. We have posted a link to this list on our webpage. It is available. If you have any questions, please do reach out. We are available via email, fpr.cra.banks@illinois.gov, or you can reach out to currently the acting CRA supervisor, Bridget Castle, or you're welcome to reach out directly to me.